Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. If you can hear me well, please say yes in the chat. Yes, Y-E-S. Put yes in the chat if you can hear me well. Hope you guys are having a fantastic Thursday. We have breaking news today. I know we haven't been on all week, but we come back with the breaking news. Breaking news, breaking news. I see the yes. I see the yes. Thank you guys so much for letting me know. I keep trying out all these mics I got around the house. I said I have them. I might as well use them, right? All right. Okay. Okay. Let me know. Like last time, I don't know what was going on. I think it was a StreamYard situation where it was in and out and all of that. So you guys, I'm gonna try to pay attention. All right, I'm gonna try to pay attention just in case we have an issue with the mic. All right. If you guys will be so kind as to hit that like button. I didn't do any type of goal right now because we have breaking news. We didn't really have time to do a goal. But if you guys would like to support the platform, please hit that super chat, super sticker. Any amount will be appreciated by the channel. Also, you can hit that Cash App if you would like to. But importantly, make sure you subscribe to the channel and hit those notifications so you won't miss whenever we go live. Well, you guys know that we have been covering the Thomas Dexter Jakes versus Duane Youngblood. And there was a lot of back and forth. This case was actually filed last November. You heard me right, last November. And it's been so much back and forth and uh, dismissals being filed and alleged AI and attorneys being withdrawn and sanctions. It's just been a lot. It's been everything but litigating this case. Well, as I was looking at a lot of the documents as we were going over it, I made the prediction. I said, you know what, at this point, I really don't even think Youngblood really wants to be in this here lawsuit. So I think perhaps they may try to just somehow let this go away. And today, folks, it looks like this case is going away. Thank you, Miss HLS, for the super chat. She said, your brows are fire. Thank you so much. Thank you. I did it just for you all. Yes, I did. Lit Twerker said, wasting the court's time, lock them up. Goodness. Okay, this is a civil case. Relax. So for those of you that have no clue what I'm talking about and don't want to go back to the videos, I suggest over the weekend you go back to the videos. Even though you'll be starting backwards because this looks like it may be the conclusion of this case. But what happened was last year around this time, Duane Youngblood, who apparently was a part of the same organization as TD Jakes back in the day before TD Jakes was the TD Jakes, and he was Elder Jakes. He was an evangelist who traveled from place to place. And Duane Youngblood was a young guy, and he alleges that TD Jakes pretty much, tried to hit on him or attempted to kiss him or something on the platform of Larry Reed. And from that point, there was a lawsuit that was filed by TD Jakes, by Bishop TD Jakes, because he didn't appreciate it. He said it did not happen. He said it was all a lie. Well, apparently, Tyrone Blackburn, who we've seen over the last year with a lot of these celebrity lawsuits. He came in to represent Duane Youngblood. And when he came in to represent Duane Youngblood, allegedly, and according to these documents that have been filed on the docket, he asked TD Jakes for like $4 million or $6 million or some $1 million, way too many millions of dollars. Okay. He was asking him for millions of dollars in order to not, I guess, file a lawsuit against Jakes for this alleged misconduct decades ago. And so TD Jakes said, listen, you're not about to bully me. I'm not giving you anything. And so he filed this lawsuit for defamation for what was said on that platform. And the first response, well, first there was a motion to start discovery early. So they wanted to get into some information with Dr. Larry Reed. They wanted to get into some type of discovery because they had something in their mind that they believed there was some type of alleged conspiracy because he went on this man's platform, that somehow maybe he may be benefiting from this. He being Larry Reed may be benefited from. That's what was alleged. The court was like, no, there's no reason for you to start doing discovery. So then I believe the next document that was filed is Tyrone Blackburn, who represented at that time, and I say at that time because you'll see later in a minute, that he filed a motion under the anti-SLAPP. Now in Pennsylvania, the anti-SLAPP was a new statute there. And the anti-SLAPP, for those that don't know, that you're new over here, we've covered it in a lot of defamation case. It's a statute that was enacted to essentially protect the little guy, because oftentimes you have where big corporations or big wigs with money, they try to sue you so you can stop talking about them because you're messing up their bottom line. So they came up with this statute in order to protect the little guy. And it started with like protesting against the states. And, it's evolved over time to the freedom of speech portion for us U.S. citizens in this here divided states of America. And so the anti-SLAPP was so new, we don't know. The anti-SLAPP is a state statute. So under certain situation, it only applies in state law, in state court, but does not apply in federal court. And this lawsuit was filed in federal court. So there was an issue on whether this anti-SLAPP even applies. I don't even know if they got to that point. All I know is that Duane Youngblood filed the anti-SLAPP and it got slapped down. Okay. The court was like, it's a no. And so the next pleading that I believe was filed was a motion to dismiss. So then Duane Youngblood, being represented by Blackburn, filed a motion to dismiss the case. Well, Bishop T.D. Jakes' team was very thorough. And they looked at every citation, every nook and cranny, period, comma, what they're paid to do. And they found that some of those quotations did not say what it was purported to say. When you looked at the actual case law, those quotes were not there. Also, allegedly, there were hallucinogenic case law, which means case law that didn't even exist. It was just a lot of issues. And so TD Jakes' team, they, under Rule 11 of the Federal Rules of Civil Procedure, they said, listen, you need to withdraw this dismissal because you got a lot of problems with this. So they listed all the problems, because that is what they're supposed to do, is they're supposed to give you a chance to correct your mistake. And then if you choose not to correct that mistake, then they can file with the docket and ask for sanctions, Rule 11 sanctions. Well, they sent him all of this letter with all of these problems that is in this letter from this dismissal. I mean, they went line by line, precept by precept. And also allegedly, I guess there was a quote from the order of the court that the court said wasn't even what the court said. All right. And go through this document. Eventually they do file it. The next thing you know, Blackburn is trying to withdraw. the court said, no, 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 no. You're not getting away like that. You need to respond to this allegation that you have used wrong misquotations. You misquoted the court allegedly, hallucinogenic case law. You're not just walking away like that. So Youngblood had to show cause why he shouldn't be held in contempt or sanctioned based on this dismissal. So he goes to court. Basically, his argument is, he being Youngblood, I mean not Youngblood, Blackburn. His argument was, listen, Judge, listen, Your Honor. What had happened was, I got new software. And in this new software, it had some updates. And apparently they had some misquotes or some type of information that may not have been accurate. I did use AI. So he acknowledged that he used AI. And he said he's a solo practitioner. More than 50%, I think he said 60% of his cases are pro bono. Can I please, 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 please get grace and mercy? Jake's team said, listen, we had to go through all of this and do all of this work because you filed this brief that was riddled with AI. So we want 70-something thousand dollars in attorney fees. So the court, in between time while it was waiting, we were waiting on the court's decision. Jake's team was still working. Okay. They went and looked at every case that Blackburn was connected to. There was some allegations of Blackburn stating on his letterhead that he was licensed in DC, and then it was a discrepancy on whether he was really licensed. If it was out there, Jake's team said, I'm going to find it. Okay, I ready or not, they were like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Ready or not, here I come. And they started looking in the closet, looking in the drawer, looking in the box, looking in the container, looking in the folder. They just was looking. And they found everything they could on Youngblood. And so there were documents going on the docket because, not Youngblood, I'm sorry, Blackburn. So there were documents that were being filed on the docket that were, again, we haven't even gotten into the first conference that we have that gives us our discovery. We didn't even get into that. This was all before, this is all like before we even have our initial conference. And so they were kind of going back and forth. And then, of course, Blackburn felt like he was being harassed. They're trying to take down a solo practitioner. They trying to ruin his career. It was just a whole lot. Now, mind you, Youngblood don't even want you to be the lawyer anymore, and you're going through all of this. And so finally, ultimately, a couple of weeks ago, the court ruled and said, yeah, you did everything they pretty much said you did, and you're going to be sanctioned. However, we're not giving you 76,000 or whatever the amount was that Jake's team was asking. We'll give a $5,000 sanction, and they gave Blackburn payment plan. So his first payment is due like November 15th, if I recall correctly. All of this is off the top of my head. And so what was interesting is even before then, there were other notices about, I want to say Tyrone Blackburn was alleging, I guess, Youngblood filed a complaint with the state bar and said that he didn't ask for the whole $6 million that started this whole fiasco. Because what Jakes is alleging is he felt like it was he was trying to extort him, like he was trying to shake him down. So Youngblood, I guess, was alleging I had nothing to do with that amount. I didn't have nothing to do with what he was asking for. Because mind you, the allegation is an attempted kiss. That was the allegation. Now, off in the beginning, I was very adamant when I found out, when I heard before we actually saw the demand letter that was filed. I was adamant. I was like, now come on. You know that's kind of high. Yes, when you do a demand letter, you leave room for negotiation, but you usually not trying to be that far apart. That's just far. You guys are like decades apart. Like, come on. And so that is what really started a lot of this. Okay. And now we are where we are. And let me thank you all for the super chats before we get to what we're here for. I hope you guys are caught up. That is the Cliff Notes. But if you guys would like to watch all the videos and see them in real time, well, I guess it's not real time, but you can see every little bit that I was talking about probably the day or within a couple of days of when they were filed. You can go to those videos. I'll attach them to the end of this video. Thank you, Catherine Mechanico, for the super sticker. I appreciate your support. You know what Patty said, let me borrow these eyebrows for the weekend. Thank you so much for the compliment. I appreciate it. Gotta love Jones. Thank you for the super chat. I appreciate that. Jackson Tabasco. Y'all like these little eyebrows. Thank you so much. I appreciate it. Thank you. Thank you. Thank you. I appreciate. Darlene say hello, Pam and the intellects. Hello, Darlene. How are you? And now, without further ado, this is what we are here for after that long beginning. Oh, first of all, hit that like button, okay? Hit the like button. Subscribe to the channel. All right, I'm putting in work over here, keeping up with these cases for you all so we can stay updated. When I was looking at some of the documents that were attached, one of the documents, I can't remember which filing it was, there was conversation of which I guess Youngblood's attorney. So what happened, for those of you that don't recall, when it comes to the representation portion of it, Blackburn is licensed in New York. He's licensed in some other places as well, but he's not licensed, or he's not authorized to practice in Pennsylvania Federal Court, the Western District. So he had to pro hoc in, which means for this time only, this one time only. So it would have been for that case. Oh, they took away his pro hoc beach. I think they would revoke that as well, as part of the sanction, and allowed his withdrawal. And now he has to attach that every time he wants to pro hoc vice within another jurisdiction. Anyways, there was local counsel that you have to get in order to pro hoc in. So you have to have local counsel that is familiar with the rules over there in that jurisdiction. And so there was already a local counsel that was there in that jurisdiction. However, I think that local counsel probably was just going to be second chair, where Blackburn was going to be the lead attorney. However, as local counsel, you assist God, kind of help them navigate in a jurisdiction they may not be as familiar with, which is the purpose of the rule. So once Blackburn withdrew and he got fired. Okay, he got fired. Youngblood was like, when all of this drama was coming out, I guess Youngblood was like, listen, you got me looking crazy out here. So he decided, I think the local counsel was like, look, it's either me or him. I think that's what happened. If I'm wrong, you guys can correct me. And so the local counsel there ended up staying on the case. So he didn't have to like go search all over and try to find someone to take Blackburn's place, because local counsel was already there. So the withdrawal didn't affect him having representation, because local counsel agreed, and they had their own agreement where they would just take over the case. And in those letters, some of the letters that were attached, it looks like his current counsel, which was local counsel, mentioned trying to somehow resolve this. And I got the little inclination early on. I felt like perhaps, and this is just speculation, that Youngblood knew that maybe a demand was going to be sent to try to get some money off this situation. However, he may not have been privy to the amount. Now, Blackburn argues that Youngblood knew about all of it because he said he sent him a draft and Youngblood made corrections. However, again, that was probably more connected to the facts. So we really don't know if Youngblood knew or did not know about that amount. But because he contacted the state bar, his argument is he did not know about that amount. And I think at this point, he realized that this is what caused all of this. And Youngblood just got out of prison not too long ago. And so he probably didn't really have the finances to be trying to fight Jakes and his 5011 attorneys from all over this here United States, divided states of America. Okay. So this is what happened today. This is what happened today. This was a filing that just happened not too long ago. There was a notice of dismissal, y'all. Thomas Dexter Jakes is the plaintiff versus Duane Youngblood et al. Plaintiff's notice of entry of dismissal under Rule 41A sub 1 sub A sub 2 pursuant to Rule 41 sub A sub 1 sub A sub 2. Plaintiff Thomas Dexter Jakes hereby gives notice that the above caption action is voluntarily dismissed by consent of all parties who have appeared in this action. This is dated October 16th. I said 16th. 16th of 2025. So we went through all of this and we never even made it to the initial conference to even get any type of scheduling order, pre-trial or nothing. And it's over, guys. Just as fast as it started, it has been dismissed. Okay. Now, if I were to speculate, I don't know why these people dismissed this case. I just honestly think that they were tired. They were sick and tired of being sick and tired. And so they just agreed to dismiss this case. Again, it was by consent, meaning both parties agreed to this dismissal. And there's that. Ray said when it started a year ago, Pam told us the ending would be lackluster. Well, I'm just saying. Thank you, Ty E. She said them November absence checks is fixed to be fat. Thank you, Thais, for the super chat. I appreciate you, bro. That is so kind of you. I seen you been on here working. Thais been on this here internet working today. Just Lisa said, was he paid under the table? I don't want to speculate to that. And the reason being is because that's not what it necessarily means. And I understand why some people might think so. But I voluntarily dismissed some cases and nobody got paid in federal court. So that's not necessarily what it means. And it could just honestly be that, again, if Duane Youngblood is contacting the bar and saying, listen, I didn't know anything about this $6 million demand, then maybe TD Jakes decided to operate in his biblical man of God essence and said, I'm going to have grace and a little bit of mercy. And I'm going to just let this go. I don't know. But we would be speculating. And perhaps he said, listen, sir, I won't talk about you not no more. And maybe that's all Bishop Jakes wanted. It's for him to keep his name out of his mouth. I don't know. I know Duane Youngblood allegedly was writing a book. So I guess if we don't see the book drop, then hey. Star Bill said, I smell a little bit of smoke, in my opinion, and you are entitled to that. Ray, that's what I'm saying. I don't know if there's going to be the book. I don't know. You said probably like drop it now or face charges. What charges, lit twerker? You must not know about what was going on in this case, because what no charges about to be filed. What are you talking about, North Media? I who you let me see what that part said. Let me see what made you all up in a bunch. Huh? Let's see what happened. Mm. For always forever said, I've been saying Blackburn is trash, take the bar Cardi is mess up. Well, goodness, I'm not a proponent of taking bar cars, but he has made a lot of flubs here. He has made a few little mess ups that we seen online, but we work very, very hard. But I mean, I guess we can't care about bar cars more than other people. I wish Blackburn the best. Maybe these are some learning experiences. Perhaps the celebrity of it all and the attention that comes with representing celebrities may have got a little bit to his head. I don't know, but I hope he gets it together. He hasn't been practicing even a decade yet. So he has room to grow and to learn, but he just has to move a little differently. Hey Christine, good to see you. Thank you, Karen. I appreciate that. Y'all gas me up. I appreciate you. Yeah, that's it. That's the breaking news, guys. Andrew said I think it was those twists that got to his head. Y'all not a Blackburn fans, huh? Not well. Jake's team wasn't a Blackburn fan either because they found if it was there. I'm not joking. It was like when we were kids, and you were like, "Tag, you're it. Okay, you gotta count. I gotta hide. 1, 2, 3, 4, 5. Ready or not, here I come." And they just started looking at every place. They said, I think they might have typed his name on the system and looked up whatever cases he was involved in. They knew every nook and cranny about Blackburn's practicing out here in these legal streets. As they should. They did their job. I think I would want to research somebody that seemed like they were using AI or what, which he has admitted to. He admitted he used the Lexus and he used Westlaw. So yeah. Richard this is the brother I think said your discernment is extremely close. Okay. All right. Thank you so much. You said AI is not bad. AI is not bad. I use it, but I don't use it. The thing about this generation, I know I just cut myself off, but the thing about this generation is a lot of us, and I've been practicing close to how long? I'm about 14 years. Um, we learned in books, these type of online research, they were out there. We learned that in law school when I was in law school, but it was after we learned in books. And so we learned how to literally open up the books, look through the pages. I don't know if they still do that. They may. However, the technology of it all, as everything else has improved, just like we don't open up dictionaries too much anymore. We go hit Google. And I think that we become too reliant on it. And it is time consuming when you have a lot of cases and you're trying to pay your overhead and you're trying to pay your staff. And a lot of this AI and this technology is, of course, capitalizing, which is what sales is. You find a need and you try to meet their needs. So that is one of the issues in law firms is just you want to have more volume because more volume brings in more money, but you can't have more volume unless you pay somebody to be able to handle the volume. But hey, if I can get AI, because Westlaw calls it co-counsel, then maybe they can help. But I think you have to find what they're more beneficial to help with. So if you want them to draft emails, rewrite certain paragraphs, uh, of course, look up the law that you already know. I think it's very beneficial. But what happens, and I told you all this before because I have both Lexus and Westlaw. What happens is you can put in an issue. So, for example, I might say, I have a client that came to me and she was caught with so and so amount of marijuana. However, marijuana is legal in Michigan. What is the implication that she was caught with it in her car? I'm just saying something random right now. And they may pull up cases, and it seems like the way they summarize it when they pull it up, they summarize it in a way that matches your, like, favorable to what you want it to be. So sometimes the way they word it, you're like, oh, shucks, this is exactly what I need because this is pro my client. And they'll give you the case law. Now you have to, and what you have to do with this AI is you need to click on the case law. Click on that case law and see what it actually says. Don't take their summary that it is what it is, because it seems like they try to fit your scenario into cases that don't necessarily fit. And I learned that early on about this software. So you click on, and sometimes it's right on point, but sometimes it's just like, no, that was the opposite side, and the actual case rules against you. It doesn't even help you. So if you take the quotes, you quote what they put in a summary, it may not even be what the actual holding is of the case, and it may be adverse to what you need a case to say to support your position. So it's not a shortcut for you not to read the cases for yourself, is my point. And I think some people believed that I can put this issue in here. They're going to pull out all these cases, and then I can just say what they say the cases say, and they really don't say that. And it's getting people caught up. Like, people are getting sanctions in the thousands for using AI. And is it beneficial? Yeah, they have certain, of course they come up with new, they're in competition. So they come up with new add-ons quite frequently. So they got to a point where if you put this in, they can write your briefs for you. They have it in where you can compare your brief to somebody else's brief, and it's encrypted. So it's supposed to delete when you finish. So it's not like your work is in the system for somebody else who may have the same program, which would obviously be a concern, because I wouldn't want to put my brief in there and I know that you're going to let the other side view it. So it eliminates that. They have side by side. They have it where you can put somebody else's brief in there. What I had a habit of doing my whole career, when the other side files motions, I look up their cases and make sure it says what it says that it says. And before AI, there were people that misquoted, but it wasn't considered like sanctionable. You may have made a mistake, but now because of AI, they know that people are using AI. So some of these misquotes maybe because you're using AI instead of actually putting in the work. AI is not a substitute. We're the beta generation. We're actually the ones feeding the system with the questions we ask, with the briefs we drop, all of that stuff. We're feeding it. Sometimes they're not totally up to date. They'll use old case law when the statute has been amended. So you just have to be very careful. But again, that's why they put their disclaimer at the bottom. We told you to make sure, double check and recheck. So you can click on and make sure that a case exists. You can click on and make sure a case says what it says. I don't have them recommend cases and I don't read the actual case and see what it says, because I promise you, a lot of the time that I've done it, it actually is against and not favorable to my position. And I don't want to use cases that are not favorable to my position. Even if they do have something in there, like they quote a law within that case, if the holding is against a person with the same issue as me, why do I want to cite it? So I think he just got caught up in the game, which is big firms. One of the biggest firms here in America got caught up in the game. So it's apparently easy to get caught up in the game. But as the court noted in this case, this is not a unique situation because we know that it happens. So there's that. Yeah, and the thousand, like Blackburn got sanctioned $5,000 for this AI situation. There was grace and mercy because there were, I think it's a law firm that got sanctioned about 32,000. Some law firms have been hit with some real amount. So he did get some grace and some mercy. So yes, Veronica, you have to do both. I'm not saying, some people are like, well, what's the point of AI if you still got to do the extra work? Because sometimes AI will pull out cases you never would have thought of. Or if the way searching online on online software works, you have to put the correct keywords in there. That's how it used to work. If you don't put the correct keywords in there, the cases you need are not going to show up. So if I didn't put, like in my example, marijuana /legal /car within the sentence, like you had to learn how to actually research it in order to get specifics on what you need. So if you didn't even know the key words, you may not ever pull up the case that you need. What AI does in these softwares is you can just write like how I'm talking to you. My client got a ticket for so and so and such and such. They illegally searched his car. He didn't give consent. There was no plain smell exception. There's no exigent circumstances. Whatever the issue is, you can write it just like that. And then AI will formulate questions for you and formulate it how you should search it and then pull up cases. So it is beneficial because there may be cases you never thought of. The issue is you still need to check that the cases say what they say that it says. That's all I'm saying. And it sounds like people are just going for what it's saying. And they have a lot of continuing education on it. So I haven't taken any, which I probably should since it's become a big situation now. So I will. But they have a lot of continuing legal education, and Blackburn was trying to use that as a way to avoid sanction by saying that he's tried to have continuing legal education, and so he was begging the court not to be sanctioned, and the court was like, listen, I'm going to take into account that you're a solo practitioner. 60% of your cases you say are pro bono. However, you're going to pay some money. Now, we'll give you some payment arrangements, but you're going to pay some money. So he was ordered to pay I think it's like $500 per month or something of that nature. He said he didn't use Chat GPT. He said that he used, and again, this legal software is Lexis and Westlaw. These are specific towards legal. So that's not, Chat GPT is just generalized. This is specific towards lawyers and what lawyers need in their firms. And like I said, very, very beneficial on so many different levels. So many different levels. On some of them, if you pay enough, you don't got to go into the courts and try to download other pleadings that might be similar to your case. They may offer you access to them. It's the convenience of a lot of the stuff as well. So yes, you just have to know how to use it correctly. And we're all navigating this space because it's new, but I'm still old school. Like, I still want to read everybody's case and make sure it says what they say that it says. And the courts have been doing that anyway, because I told you guys, I was in federal court one time and they were talking about the entity I was going against, and was like, well, who do you guys got working over there now? Because this isn't the first time where these citations are off. So who is over there? You need to tell them they need to watch these citations, because they don't, that this citation does not match this case. The case name exists, but these citations are wrong. And the federal court, since I can remember, since I've been practicing in federal court, which has been in the beginning of my career, they've always been very thorough and check your cases and check your citations. Always have. Um, let's see. I'm trying to see, NORTH media. I'm trying to see all this going back and forth, but I can't never see anybody's. Okay, let me see. First of all, I said I heard like everybody heard he was, and there was a photo, whether it was misleading or AI, not the one that posted it. Girlfriend. Okay, what are you talking about? Let me go back. Let me go back, guys. I was trying to find that before and I couldn't find it in the chat. Ah, okay. So at that part stated Bishop was part of no, we have no proof that he was a part of any freak offs. No. Absolutely not. Now I would have to agree with North Media. That is not accurate. What ended up happening was DD Jakes has denied it. He had to sit down with Oprah Winfrey and he said that it was not true. He said he stopped by a party that Diddy had, and because of that picture, that's how it all started. We started seeing AI of people having him in compromising positions with Diddy on their thumbnails. Jake sued to try to, I guess these videos, from my understanding, were from another country. So he filed a lawsuit in California where he was attempting to get the username. That's why some of you guys that think that you're safe on this internet, you're not safe. Now, Google doesn't necessarily just give you all information when you ask for it. They're a tough cookie. But when the court says you shall turn this over via subpoena, you're turning it over. So he went to the courts and asked for subpoenas in order to trace the IP addresses on where this AI and these videos originated from. Jakes did this at the same time, around the same time that this Youngblood's lawsuit came out. So we have to be careful. That's not true. I understand if you heard it. We have no information that ever happened. And all I can say is he denied it, and I have to go by that he denied it. Diddy ain't never say it happened either, so that's what we have to go on. Let me see what happened with that case. Actually, that was against Google while we are on here. Since we just had, so if you guys are just coming in, please make sure you hit that like button and subscribe to the channel. The case is over, guys. TD Jakes versus Duane Youngblood. It's over. Well, it's over when, the court acknowledges it. But yeah, there has been a notice of entry of dismissal that has been entered in on today. I'm trying to see where against YouTube. So there was a subpoena. Let me look this case up for y'all, since I brought it up. You guys give me one moment. Northern District. That case was closed August 11th of 2025. It looks like it was an NRA ex parte application. So the entire suit was to try to get this information. So there was a judgment. Let me see. Hold on. Oh, he got something in order. He actually won something. Hold on. So it looks like all right. See, I wasn't even keeping up with this case. Oh, this is interesting. Hold up, y'all. So, according to this, let me see, motion to quash. This anonymous YouTube user that he was trying to get the information from filed a motion to quash. So Jakes must have got the subpoena. Okay, he got the subpoena, was allowed to subpoena these people. And so one of the individuals requested that the subpoena be quashed, meaning asking the court to quash it, not making him have to do it. And so let's pull that up. Let's pull that up. I didn't even know that happened. My goodness. So much. We were doing this Youngblood stuff. All right. So what happened was I told you all TD Jakes, Bishop TD Jakes filed a application in order to get information on these AI videos on YouTube. This is a lesson for some of you guys that think you can just throw your rock and hide your hands too. And the court was allowing the subpoena. So these individuals were subpoenaed. One of the, when you get subpoenaed and you feel like you shouldn't have to abide by the subpoena or you object to the subpoena, you can file what is called a motion to quash the subpoena. And that is you try to get the court to not make them produce the documents or produce the information that they are requesting, and they come up with various reasons why they shouldn't have to produce it. So apparently this anonymous person, Prof X, that's their pseudo name, they responded trying to quash the subpoena by Jakes. And this is what they said. Prof X, an anonymous YouTube user and non-party to the above caption matter, respectfully moves this court to quash the subpoena issued to Google LLC pursuant to the application of TD Jakes. The subpoena seeks identifying information associated with the YouTube account linked to the email. The subpoena infringes upon the movement's First Amendment right to anonymous speech and fails to meet the legal standard for unmasking anonymous speakers under applicable U.S. law. So this person started, of course, you guys know, because some people in this chat probably right now got fake pages because they don't want people to know who they are. We go get a Google account. And like I said, Google automatically does not just say, well, I need that email address from this person in the chat called, ABC, I don't like me. They don't just give it to you. But if they get subpoenaed by the court, they may have to produce that information. And typically you subpoena to get all information related to the email address, like their personal information. Why? Because you're probably going to sue them. So when they gave the information to try to subpoena them for personal information from Google, I guess they tried, this anonymous person is trying to quash. So the background is Prof X is an anonymous content creator based outside the United States in South Africa, who publishes material on matters of general interest. The content is created under a pseudonym and is not affiliated with any commercial entity. The subpoena served to Google seeks identifying information regarding this anonymous account with no underlying complaint or cause of action in which the anonymous speaker is named as a defendant. The argument, the right to anonymous speech is constitutionally protected. They cite McIntyre v. Ohio Elections Commission, the 1995 case. The applicant has not met the burden required to unmask a speaker. To pierce the veil of anonymity, courts require showing a specific facts establishing a prima facie case of actionable harm as outlined in Doe v. Cahill. Mere displeasure with criticism or reputational damage is insufficient to override First Amendment protection. You do know you were having like thumbnails of him in the bed with he's a whole bishop. You do know that, Mr. Anonymous, right? The speech at issue is non-commercial and lawful. It is on YouTube. So I don't know how it's non-commercial, but there is no indication that the content posted by the anonymous user is unlawful or commercial in nature. Even if it were critical or controversial, it falls under ambit of protected free speech. The subpoena is overbroad and not essential to any pending action. There is no underlying lawsuit against the anonymous user, and no compelling interest has been shown that justifies the extraordinary step of compelling Google to reveal identifying data. So the relief requested was to quash the subpoena issued to Google as it pertains to the account link. So what happens is when Google gets these subpoenas, they contact you and they'll say, listen, we got this subpoena from Google. If you don't do a motion to quash within a certain amount of days, we're giving them the information they ask us for. So this is what happened. They got an email from Google, like they trying to get into your email. They trying to get all your identifying information. So you have this amount of time to file a motion to quash. So this is what this anonymous person must have done. This is interesting. So let me see what Jake's response was. Hold on. So that was their argument, trying to avoid accountability. All right. So let's go back to this docket here. There was an opposition, of course, to the motion, and it was only like 4 pages. So that should be pretty quick. So let me see. We always find something when I'm supposed to be on here for 10 minutes. Opposition to non-party Prof X's motion to quash subpoena. Applicant TD Jakes has been the subject of a flood of false and defamatory allegations published by anonymous YouTube users residing outside of the United States. As a step to clearing his name and vindicating his rights, Jakes applied to this court for assistance in uncovering the identities of certain anonymous international YouTube users who have published false and defamatory allegations about him. One such user with the email address, and it has their email, maintains a Profex and resides in South Africa. On May 30th, 2025, this court conditionally granted Jake's ex parte application for issuance of a subpoena to Google LLC under 28 U.S.C. Section 1782, directing Jakes to formally serve Google the subpoena requested identifying information. Among other things, the court's order straightforwardly instructed that Google and each account user whose information is sought may file no later than July 11, 2025, a motion to quash or modify the subpoena or for entry of a protective order. Respondent Google has not moved the court to quash or modify the subpoena. On July 25th, 2025, a full 2 weeks after the court's July 11th deadline for motions to quash, the anonymous YouTube user Prof filed a pro se motion to quash the subpoena. In his motion, Prof X identified himself as YouTube user with the Gmail account address, declared that he is a non-U.S. resident currently residing in South Africa, asserted that the subpoenas infringes upon his First Amendment rights to anonymous speech. I know where they're going with this one. and fails to meet the legal standard of unmasking anonymous speakers under applicable U.S. law, and contended that the subpoena is overbroad and not essential to any pending action. Prof X thereupon asked the court to quash Jake's subpoena to Google as it pertained to his YouTube account, and also to prevent Google from disclosing any of his personal identifying information. Prof X's motion is due to be denied for a host of reasons. For one, it is untimely. Court gave him a certain amount of time. Now, what I will say is the few people that have been subpoenaed through Google that contacted me, by the time Google lets them know that there was a subpoena, it's usually too late. The couple of times that I've dealt with Google and people have called me for this same situation, the deadline is passed. So I don't know if Google just, I've seen somebody got it like a month or two later. So they probably had already provided the information or whatnot. But anyway, Jake said it was untimely, which it sounds like it was. The court's May 30th order gave Prof X until July 11th to file a motion to quash, and Prof X has not represented to the court that Google failed to timely notify him of the subpoena. See, that's what I'm saying. If that was the case, he should have put that in there. Despite having had almost a month and a half to file his motion, Prof X waited to file until 2 weeks after the deadline. In an apparent attempt to mitigation, Prof X represents that on July 11th, he emailed Jake's counsel with a copy of his motion, but none of Jake's attorneys ever received such an email, meaning they learned of the motion only when it was belatedly filed with the court. A motion filed and served so far out of time, heedless of a clear deadline, and with no justification for a delay, should be denied, regardless of the movant's pro se status. And they have Raspberry v. Garcia as their authority over there in the Ninth Circuit. Not only is Prof X's motion untimely, but more importantly, it is meritless. His First Amendment argument fails. I knew they was going to say this. First and foremost, because he's a foreign citizen, residing outside the United States. And it is well settled that, quote, foreign citizens outside of U.S. territory do not possess rights under the U.S. Constitution, including under the First Amendment. Even if, counterfactually, Prof X were eligible to assert a qualified First Amendment right to be anonymous, Jake's pleadings would overcome it. To unmask an anonymous defamer, even one asserting a First Amendment right to be anonymous, a plaintiff must simply persuade the court that there is a real evidentiary basis for believing that the defendant acted unlawfully and caused real harm. Jake's defamation claims have more than sufficient evidentiary basis, as reflected in the declaration of Dustin Posh, and that's the same person that's representing him on the Youngblood case, or was representing him, appended to Jake's application for issuance of a subpoena. For that reason, too, Prof X has no right to be anonymous in this here case. Prof X also contends without elaboration that the subpoena is overbroad, but he's wrong. The subpoena seeks only information necessary to identify Prof X, and that means he used to publish his defamatory accusations. It expressly requests documents sufficient to show the identities of the anonymous defamers. Not every piece of information Google possesses about the limited set of users identified in this action. Probably want your information so they know who to name in a complaint. It's probably what they wanted the information for. That is the bare minimum needed to facilitate the contemplated lawsuit. See? Before I read it, I already knew. They just want to know whose name to place on that defendant section of this here lawsuit that they planned on filing. Finally, Prof X argues that the subpoena should be quashed because it is not essential to any pending action. But Section 1782 sub A does not limit the provision of judicial assistance to pending adjudicative proceedings. And that's Intel Court v. Advanced Micro Devices, and that's a United States Supreme Court case in 2004. Rather, the proceedings for which discovery is sought under Section 1782A must be in reasonable contemplation, but need not be pending or imminent. So you only have to have it in contemplation of suing you, sir, ma'am. For all these reasons, Prof X's motion should be denied. Jakes respectfully requests that the court order Google to produce the limited and necessary information sought to identify the anonymous South African defamer. This is a lesson to some people. I'm telling you. I told somebody that before. I was like, listen, I know you guys try to hide behind these anonymous names. I remember when I filed a video on one of my clients, and somebody did a very suspicious comment. I was like, I should really try to figure out who that is, because they sounded like they really knew about my case and they were trying to persuade other people or whatnot. So, but nonetheless, let's see what the court ordered on that case. So Jakes prevailed. He has a judgment on August 11th of 2025 as the court conditionally granted petitioner Bishop Thomas Dexter Jakes' application for the issuance of a subpoena to respondent Google LLC under 28 USC section 1782, which is also located on the docket ECF 20, and denied a motion to quash the subpoena. Judgment is entered in favor of petitioner Jakes. The clerk of the court is requested to close the case. So Google had to give him the information. So that is probably why we stopped seeing all that AI all over your timeline of Bishop T.D. Jakes. So that is that case with the anonymous situation. Is that it? I'm glad I did pull that up, because I usually try to complete whatever I talk about, and I didn't even go back to that case to see what happened. Oh my goodness, you guys are arguing over who is God's child and who is not God's child. I need you guys, like, come on. Let's be respectful. We don't know people's relationship with God, all right? Don't act like the colonizer, guys. Don't act like the colonizer. Well, they think that Jesus belongs to them. That's why he's white with blue eyes. He's their property, and he can decide who Jesus loves and who he don't love and how he don't love them and all of that. Let's not do that, okay? We don't do that over here. So yeah. Let's see. Robert said, also, Pam, we need you on Inside Edition at 7:30 and 4:30. Who is that? Tonight on the story, and we'll keep you posted and see you with Vinnie Politan investigates at night. What I miss here? What I miss? Thank you, Cindy, for being a member for 15 months. I appreciate it. I really, 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 really do. So there's another person that is indicted by the DOJ. Who? What just happened? You said you'll plead the fifth. Yeah, no, that's what we do. We ain't got no listen. We asked lawyers for Duane Youngblood to respond to the allegations, but we haven't a call back yet. You said, I think that's what Hoover. I haven't looked up Hoover's cases on Ernest Williams. I'm going to be honest. So I don't, although I'll read it with you all and explain it, but it's very rare. There are some videos where I looked up the case law and I looked up like the statutes, but for the most part, that's so much like work. And the thing I like about YouTube is it's work, but it's usually based on my personal knowledge from being practicing as long as I practiced. So I don't really, it's not like I'm trying to fix my signature to something to submit to the court. So I don't put as much work in to say, let me make sure what Hoover says is, or what and Wooten says in these cases are accurate. I don't put that much time into it. Don't put that much time into it. At Pam, that's what I said. It was alleged and it could have been AI or misleading, period. Okay, I write that part. I got you. You know, I don't want no smoke. I just wanted to make sure that we're clear. We don't want to defame nobody over here on this part. Thank you, Catherine, for the super chat. Said this is good. We need to be careful what is typed. We do. John Bolton. What? Oh, Trump is busy. Wait a minute. Let me look that up. If you guys are in my membership, you guys probably don't remember at this point because I talked about this case probably when I first started the channel. That was in 2022-ish or 2023, something like that. Trey Songz has settled that case he has in Miami where Ariel Mitchell was on the case. That case has settled. That document was dropped in the membership. Let's see here. Is that on the Shade Room or something? They said the government shutdown is going to be 39. They predicted to be 39 days. That's tragic. All right, let me pull. You said Bolton, John Bolton. One thing you guys are going to do is take my. I'm going to only be on for a few minutes to me being on way longer. Let me see. Indictment. Former Trump's national security advisor, John Bolton, indicted. So he don't like him? I didn't know they were beefing like that. I remember him. I don't remember. Okay, wait a minute. Let's pull this up. Former. These ads are annoying. When I tell you. John Bolton, President Donald Trump's former national security advisor turned adversary, has been indicted by a federal grand jury in Maryland. He now faces 18 charges. My goodness. 8 counts of transmission of national defense information and 10 counts of retention of national defense information. Prosecutors wrote in the indictment that during the time he was national security advisor to Trump, Bolton shared, quote, more than 1,000 pages of information about his day-to-day activities, end quote, with 2 unauthorized individuals. Both of these people were related to Bolton and didn't have the authority to access classified information. So he was at home talking to his wife and brothers and sisters or cousins or aunts or uncles. That's interesting. That's a conversation, I guess, at the family reunion. Printouts of diary entries were also found in Bolton's home, according to the indictment. Bolton is expected to surrender himself as soon as Friday to authorities at federal court in Greenbelt. His case was assigned to Judge Theodore D. Chung, who was appointed to the bench by President Barack Obama in 2014. The FBI's investigation revealed that John Bolton allegedly transmitted top secret information using personal online accounts and retained said documents in his house in direct violation of federal law. FBI Director Kash Patel said in a statement, the case was based on meticulous work from dedicated career professionals at the FBI who followed the facts without fear or favor. Weaponization of justice will not be tolerated, and this FBI will stop at nothing to bring to justice anyone who threatens our national security. Bolton, who has been under investigation for alleged unlawful handling of classified information, becomes the 3rd high profile Trump political enemy to be indicted in less than a month. The underlying facts in this case were investigated and resolved years ago. These charges stem from portions of AMB. Guess they said, child, you reading our stuff, we're going to put up our ads. Bolton's personal diaries over his 45-year career, records that are unclassified, shared only with his immediate family, and known to the FBI as far back as 2021. Bolton's lawyer, Abe Lowell, told CNN in a statement, quote, like many public officials throughout history, AMB, Bolton kept diaries that is not a crime. We look forward to proving once again that basically he ain't unlawfully shared none of this here information that he is being accused of. All right. Well, there's that. Thank you so much for the breaking news. I appreciate it. Okay. Thank you. Thank you. Thank you. Thank you. It's a lot going on over there in DC. I'm gonna stay over here on this here platform where it appears to be safe. But you all, thank you guys so much for supporting the platform. And I'll probably be back tomorrow to see what happens with David E. Taylor. For those that don't know, go watch the video so you can be prepared for tomorrow. David E. Taylor is in Michigan now. He is supposed to be arraigned on tomorrow. And the government, just like with Michelle Brannon, is asking that he remain detained. Michelle Brannon was able to get out on bond, and they're trying to keep David E. Taylor in. So their argument will probably be tomorrow. I'll have court in the morning in person. So if I finish court in time, then I'll swoop on over there to the federal court and see if I can see Bishop David E. Taylor face to face, like he said he sees with Jesus. See if I could see him face to face, because I need to know if he just, some people just may take pictures and they just don't look good in pictures. Maybe he looks a whole lot better in person. And I just need to see it for myself. But anyway, you guys. Yeah, she got bond. So anyway, see, now this turning into politics. I ain't trying to do that, y'all. I'm trying to keep my little monetization on here. So you guys have a good night. Make sure you hit the like button. If anything else happened, we'll be back. And rest in peace to D'Angelo, child. We got so much bad news over the last week. I'm like, can we get a break? One of my friends lost his mom. One of my old church members passed. D'Angelo. I was like, it's just a lot. So you guys pray for the grieving heart. But grief is the price we pay for love. Some people have never loved, So anyway, I'm gonna holler at you guys later. You guys have a great night. And until next time, you guys subscribe to the channel. Thanks.